Okay, so first we're going to take a look at our scenario, or which is what are our situations in our scenario. It's about Cynthia is a university student who are very outspoken and very active, engaged in various of social issues, particularly all those related to the social and economic justice in her country. One day, she found out from her friends that the local authority planned to demolish all those illegal structures that was built without permissions and license. Additionally, they will also persecute all those individuals who set up the store without a license, and also they plan to capture all stray dogs in the area. Cynthia under believe that the policies, the decision and the actions provided of the authority by the authority are very unfair, unjust and very inhuman.
So, as a response to the government decisions, Cynthia decided to organize a meeting with her fellow activists to discuss about these issues. Together, they decided they would like to criticize the government through social media. They believe that the actions of the government very unfair and very injustice. So, they had accused the authorities of practicing discriminations and claimed that some officers are racist. Even they claimed that some of the officers will exhibit religious bigotry. Furthermore, they plan to conduct a free demonstration outside the public authority office. Cynthia and her friends believe that they were protected by the Part 2 of the Federal Constitution. So for our legal issues, we rely on Article 10. First is actually on the Article 10, clause 1, paragraph A, on the freedom of speech and expressions. Secondly, on Article 10, clause 1, paragraph B, right to assembly peacefully and without arm. Lastly, on Article 10, clause 1, paragraph C, which is the right to form associations. So our first issue is on whether Cynthia's actions of criticizing the local authorities in the social media is subjected to the freedom of speech and expression under the Article 10, Clause 1, Paragraph A of the Federal Constitution. So we are moving on to the rules of the first issue. Article 10, Clause 1, Paragraph A provided that every citizen has the right to freedom to freely making a speech and freely to express themselves. Article 10 only applicable to citizens of Malaysia. Nevertheless, this provision, even though everyone have the freedom to speech, there are certain limitations under circumstances that need to be followed. This is following that there are some agreements pertaining to the scope of expressions that was actually interconnected with the human value and communications. In the Supreme Court, in the case of Attorney General for Canada and Dupont against the City of Montreal, the word the judge in this case held that the word expressions only confined to speech rather than the conduct. The court in this case held that street demonstration is not considered as speech. It is actually an collective action. Nevertheless, the decision was criticized by Richard Mann. They stated that communication should not be limited to the linguistic communication only. It should have been extended to the intention to represent or express some state of way of fact and intention to convey or communicate that representations to represent to another person. He also argued that the meaning of expression shall be extended to the assembly and associations, following the fact that it is also a form of self-expression. So, by following the opinion read by the Richard Moon, we agree that the term expression is not limited to speech only, or limited to speech only, or writing only, or even publication only. It also includes the right of person to assembly and demonstration, but it should be noted that there is a limitation that shall be imposed to safeguard the freedom of expression. According to Oxford Learner Dictionary, they have defined the speech as a freedom to express opinion. So based on this, so according to Oxford Learner Dictionary, speech could be defined as freedom to express opinion. This is actually in line with the opinion of the Richmond as well as in line with the purpose of the Article 10, Clause 1, Paragraph A of the Federal Constitution that everyone have freedom to express themselves, to speak for themselves, has freedom to write or publish anything. According to Article 13 of the International Covenant on Civil and Political Rights (ICCPR), stated that it is a freedom to seek, receive, and impart information in all kind of form, either orally, it could also be in writing, or in term of in printed versions. Freedom of speech could be also in another form of art. Art also could be expressed considered as freedom of expression or any other media. According to Article 9 of the Universal Declaration of Human Rights UDHR, but despite everyone's freedom to speech, everyone have the freedom to express themselves, there are certain limitations that need to follow to safeguard the freedom of speech. So even though Article 10, Clause 1, Paragraph A provide freedom to speech and freely to express, every citizen are special to express themselves, but those rights were limited by a various laws. For freedom of speech, it was limited by Article 10, Clause 2, Paragraph A, provided that if it was found out that such speech or expression will affect the security of Malaysia, affect the public order, affect the morality, or even affect the privilege of Parliament or any legislative assembly, the Parliament may have right to impose such law to restrict such freedom of speech. Furthermore, under Article 149 of the Federal Constitution provided that even though it was a constitutional basis to freely make speech or express oneself, but if this matter of freedom of speech have affected or could threaten the national security, specifically, this Article 149 allows the Parliament to enact law to stop or to prevent action that considers to be prejudicial to the public order as well as the security of the country. Even if the law was inconsistent with Article 5, 9, and 10 or 3 of the Federal Constitution, the law would still be valid as long as they were enacted for the purpose of Article 1 under Article 149. For following this, even though the constitutional freedom of speech is considered as one of the constitutional liberty, it shall be subjected to the legislative limitations under certain circumstances. There were to protect, especially when it was done to protect the national security and when also where the public interest were at stake. So one of the law there was legislated under Article 1 by applying in this scenario. In the case of the actions of Cynthia, has actually formed the foundation of in this case, freedom of speech. It was held that the right to express the constitutional right to be seditions in her social media actually could not be protected and this action was actually in line with the purpose of the 10 plus 1 Constitution and it shall be subject to the liability under Sedition Act and expressing herself against the actions of the government, then he is a member of Parliament. He was charged under Sedition Act 1938 he may subjected to the jurisdiction under Article 10 in the Parliament where he suggested that since all the non-Malay schools shall be demolished racial and religious discrimination in order to promote unity. Cynthia could not the federal court in the case on the Article 10 that although Article 63 shows restricted to the Article 10 Federal Constitution protected the parliamentary stage by the fact that he called the government as a racist violates the office of the government, it shall only be subjected to the protection. This actually could indicate he found liable under the sedition racial and religious hurt. Therefore, this federal court under the restriction of Article 10 affirmed that freedom of speech is subject to restriction. Acquisition was especially without when the speech focused on the national issues. Despite the fact that her criticism were justified in the legislative text under this article is next Communication and Multimedia Act 1998. Since Cynthia has filed a statement on her social media provided that as indicating that official action section 233 subsection 1 provided should be subject to Constitution Act 1948. So lastly, from the defensive, indecent or false or meaning posted on the social media with the intention to annoy, abuse, to the liability under the threaten to set an extent harass another person, then will be subject to section 233 subsection of the Communication and Multimedia Act 1998. So, in conclusion, Cynthia's actions of expressing her dissatisfaction with the local authority by criticizing the public policing on her social media, as well as organizing a demonstration, could not fall under freedom of speech, since the statement was considered to be a racial and religious discrimination. She shall be subjected to the Seditions Act, since her statements were seditious, inflammatory, and racial in nature that likely to incite the public disorder.
Next, for the second issue in regards to the right to assemble, the issue that we constructed is whether Cynthia and her fellow activists' right to peaceful assembly under Article 10 Clause 1 Clause B of the Federal Constitution permits their plan for fiery demonstration outside the public authority's office. Right to assemble was laid down under Article 10 Clause 1 Clause B of the Federal Constitution, where it guarantees all Malaysian citizens' right to assemble peacefully and without arms. So everyone has this right. But it was stated that in the statute, all citizens instead of all persons, meaning that the right to assembly only conferred and exclusive to Malaysian citizens only, and non-citizens don't have this right even if they conduct and assemble peacefully without arms. So what is actually defined as an assembly? The term assembly is actually not defined in the Federal Constitution or anywhere else, but in the case of public prosecutor and Ismail, the court interpreted the term assembly widely and broadly, where as long as there is a gathering of people, it will be constituted as an assembly. So even prayer meetings like Solat Jumaat can be considered as an assembly. Demonstration and processions also are an assembly. But every general rule has its own restrictions or exceptions, and the same goes to the right to assemble, where the restrictions was conferred under Article 10 Clause 2 Clause P of the Federal Constitution, where Parliament can impose restriction on assemblies for the purpose of public order, security, morality, as well as community welfare. So if the public authority feels like the assembly will disrupt the public order, security, morality, or community welfare, the public authority can interrupt the assembly and even held the assembly as unlawful. And under Section 141 of the Penal Code, unlawful assembly is when 5 or more persons have the same intention to use criminal force, to commit mischief or trespass, to seize property, and etc. So instead of conduct the assembly peacefully without arms, they conduct an assembly to create chaos or disruptions, which is contrary with Article 10 Clause 1 Clause B of the Federal Constitution. Moreover, for the purpose of ensuring the assembly was conducted peacefully without arms, police permit was required under Police Act 1967. Under Section 27, subsection 2 of the Act, it states that anyone planning to conduct an assembly, meeting, or processions also must apply for a police permit first, and the district police chief will only grant the license if the assembly is seen likely not threaten the public peace or national security. And this can be illustrated in the case of Chia Beng Po and others and public prosecutor, where in this case, 42 lawyers were charged for unlawful assembly because they conduct an assembly without the permit. Therefore, the court held that even spontaneous gatherings require a valid police permit. So any assembly required a permit first, no matter what. And then they challenged that it was unconstitutional with Article 10 Clause 1 Clause B of the Federal Constitution, but it was failed as the police permit under Section 27 of the Police Act is for the purpose of maintaining public order. Therefore, it was upheld as not unconstitutional. However, Section 27 of the Police Act have been repealed and replaced by the Peaceful Assembly Act 2012, in which this act still requires notice or permit for assembly, but it is more transparent and less strict. Under Section 5, Subsection 1 of the Peaceful Assembly Act, the organizer of the assembly must notify the police to conduct an assembly 5 days prior. And it's not even a notice or permission, you just need to notify the police. So at least 5 days before the assembly, they must give notification or notify the police about their assembly that will be conducted. But this notice is just a procedural, so the police cannot reject or cancel their assembly even if they fail to give notice beforehand. This can be seen in the case of public prosecutor and Eunice Warren, where in this case, the respondent was charged under Section 9, Subsection 1 of the Peaceful Assembly Act for failing to notify the police. So the Court of Appeal ruled that the notice requirement is just a procedural and not a restriction for right to assemble under Article 10 Clause 1 Clause B. And even if it was considered as a restriction or compulsory requirement for an assembly, it is reasonable and necessary to ensure public order because the police was notified about the assembly and therefore they can manage the assembly. So it is constitutional. Moreover, Section 27A of the Police Act, police have the power to intervene or interrupt assemblies that not only held in public places but also on private premises if it was seems as a threat to national security, public order, or public peace, and the non-compliance with these police orders, if it was found that their assembly is found as a threat and cause disorder to the national security, public order, or public peace, and their reluctance to follow this order may result them to criminal charges. And from human rights perspective, we look at Article 20, Clause 1 of the Universal Declaration of Human Rights, where it affirms that everyone has the right to peaceful assembly and also in association. And also Article 21 of the International Covenant on Civil and Political Rights also guarantee the same right, but the same as Article 10 Clause 1 Clause B of the Federal Constitution, it also can restrict the assembly for the sake of public order, health, morals, or others' right. So we can see that it's in line with the right conferred under Article 10 Clause 1 Clause B, even though we have the right to assemble, but the balance need to be maintained for the public order and safety. To apply the rules in this scenario, even though Cynthia's planned demonstration is described as fury demonstration, it still falls within the scope of peaceful assembly, which is protected under Article 10 Clause 1 Clause B of the Federal Constitution, because the use of the word fury doesn't automatically mean that the assembly is violence and will cause public disorder. unless there is a real or imminent threat of violence or disturbance from the assembly, then the assembly remains constitutional and lawful. There is also nothing to suggest that Cynthia and her group intend to cause violence, to incite hatred, or to disrupt public order. And their goal is simply to express dissatisfaction with the local authorities, which is a form of political expression, and therefore trying to restrict this assembly by relying on Article 10 Clause 2 Clause B would be disproportionate and unjustified, as there is no real or imminent threat to public order. Furthermore, the chosen venue, which is outside the local authorities' office, in fact actually a public area, but was not one of the prohibited places listed in the first schedule of the Peaceful Assembly Act 2012, like hospital or public park. And the location of the demonstration makes sense since the protests are directed at that very authority. There is also no valid basis to label the gathering as an unlawful assembly under Section 141 of the Penal Code, even if Cynthia failed to give the 5-day notice required under Section 9, Subsection 1 of the Peaceful Assembly Act. This procedural failure does not render the assembly illegal or unlawful, as confirmed in Public Prosecutor and Eunice Warren. Failure to comply with the notice requirement does not invalidate the right to peaceful assembly, and therefore, the authority cannot rely solely on this procedural issue to restrict the protest. Therefore, the assembly remains lawful and protected as long as it is peaceful. So to conclude, Cynthia's planned protest is protected under Article 10 Clause 1 Clause B of the Federal Constitution as long as it remains peaceful and unarmed. Unless the Assembly poses a genuine threat to public order, any restrictions under Article 10 Clause 2 Clause B of the Federal Constitution will be unjustified.
Okay, now for the last issue or the third issue is whether Cynthia and her fellow activist formation of a social activist group and their coordination of meetings in response to local government policies are protected under the right to freedom of association as guaranteed by Article 10, Subsection 1, Para C of the Federal Constitution, the relevant domestic laws, and the international human rights instruments. Now, in regards to the rules, pursuant to Article 10, Subsection 1, Para C of the Federal Constitution, every citizen has the right to form associations, unions, or society. But this right is not absolute, provided in Article 10, Subsection 2, Para C of the Federal Constitution allows Parliament to limit this freedom if such restrictions are deemed necessary in the interest of national security, public orders, or morality. This can also be further referred to a few Malaysian cases that discuss the idea of freedom of associations. So the first one is the case of Nordin Saleh against State Legislative Assembly Kelantan, where the court declared that freedom of associations includes not only the right to join but also the rights to not join it. So requiring a person to become part of an association is considered as an infringement of the basic rights because freedom of association involves the will to form or not to form, to join or not to join. And then the Supreme Court upheld this ruling in the landmark case of Dewan Undangan Negeri Kelantan against Nordin bin Saleh, where the court stated that the court applied a broad interpretation of Article 10 Subsection 1 Para C, deciding that the right to association covers both joining and living in associations. The federal courts, on the other hand, took a more restrictive view in Malaysian Bar against Government of Malaysia, where this case dealt with an amendment to the Legal Professions Act, and the bar argued that this amendment breached Article 10 Subsection 1 Para C. However, the judge in this case wrote that Article 10 Subsection 1 Para C guarantees only the right to form associations, but not the right to manage or regulate them as the association seems fit. But he held that Parliament might regulate how associations operate, including who may become members or hold posts. So apart from judicial interpretation, there is also statutory laws, particularly the Societies Act 1966, which has limit the right to freedom of associations. Section 2 defines any club, company, partnership, or associations of 7 or more persons regardless of its purpose as a society, and it is an offence for such societies to engage in organised activities without prior registration with the Registrar of Societies. And Section 6 empowers the Minister to declare any society unlawful. And Section 18, the Minister's decision is considered final and not subject to judicial review. So these provisions provide the executive with broad discretionary powers which can be used to limit the exercise of freedom of associations, and this can be proven in the case of Dr. Muhammad Nasir, in which the court upheld the minister's decision to reject the registration of a political parties on the basis of public orders and morality. And the next one, Section 18 of the Societies Act allows an appeal to the minister to be submitted within 30 days after a registration refusal. And the minister whose judgment is final may confirm, reject or modify the registrar's decision. So this can be seen in the case of Abdul Hakim, where the court reaffirmed the minister broad discretionary powers. Apart from that, there is also Universities and University Colleges Act of 1971 is another piece of legislation that restricts students' freedom of expression and organization. So under Section 15 of this Act, university students may not associate with, be affiliated with, or express support, sympathy or opposition to any political parties or labor union. Furthermore, university employees also are restricted from engaging in political activities. So apart from that, in analyzing the subject in terms of human rights, it is evident that freedom of association is protected by Article 22 of the International Covenant on Civil and Political Rights and Article 21 of 20 subsection 1 of the Universal Declaration of Human Rights. So these both rules ensure that every individual has the right to freely associate with others, include the formation and be a member of group for ideological, political, social, cultural or other lawful goals. However, this right is not absolute. Restriction may only be imposed in accordance with Article 22, subsection 2 of the ICCPR if they are prescribed by law and required in a democratic society for the protection of public safety, public order, national security, public health or morality, of freedoms and rights of others. So through its jurisprudence, the Human Rights Committee has made it clear that any restriction on the freedom of associations must adhere to the legality, necessity and proportionality requirements, and any domestic legislation that prohibits associations on the basis of political, ethnic or religious belief need to be closely examined, particularly if it affects the disadvantaged or minority groups. So in applying these rules to our scenario, Cynthia is a university student and she has exercised her rights to form a social activist group and organize the meeting, and this clearly falls within the scope of Article 10, subsection 1, para C of the Federal Constitution that guarantees the freedom of association. However, this right is not absolute because under Article 10, subsection 2, para C, the government may impose restriction if the issue is related with public order, national security or morality. So Cynthia's activism, especially the planned fury demonstration, could be viewed by the authorities as a threat to public order, which justify potential restriction under this provision. So in the case of Nordin bin Saleh and Dewan Undangan Negeri Kelantan, it confirms that freedom of association protects both the formation and dissolution of association, and which has been provided in Article 10, subsection 1, para C. However, as shown in the case of Malaysian Bar and Government of Malaysia, the right to associate does not grant absolute control, which allow Parliament to regulate such matters. So in Cynthia's case, while she has the constitutional right to form and join her activist group, the group must operate within the legal framework, and any restriction imposed by Parliament or authority must be justified and must be lawful. Additionally, in regards to statutory limitations, the Universities and University College Act 1971 restricts university students' involvement in political activities and association with political parties or union. So although Cynthia's group focus on social justice rather than direct political party activities, but this restriction may be interpreted broadly by the university or authorities to limit her activism. The second one, Cynthia and her group must comply with the Societies Act 1966, which requires association of 7 or more persons to register with the Registrar of Societies. So failure to register or conducting unregistered activities may lead to legal consequences. So the minister has broad discretionary powers to declare a society unlawful on grounds such as public order or morality, and this can be seen in the case of Dr. Nasir bin Hashim and Abdul Hakim. So apart from that, in regards from a human rights perspective, Cynthia's right to freedom of association is supported by international instruments like Article 22 of the ICCPR and Article 21 of the Universal Declaration of Human Rights, so which these two articles protect the right to form association for social, political, or cultural purposes. However, any restriction imposed must be prescribed by law and meet the test of legality, necessity, and proportionality. As emphasized by the Human Rights Committee, and given the sensitive nature of Cynthia's activism, especially her group's criticism involving allegation of discrimination, any government intervention must be carefully analyzed to avoid unjustified interference. So lastly, in conclusion, while Cynthia's formation of a social activist group and her coordination of meetings are clearly protected under Article 10, Subsection 1, Para C of the Federal Constitution, but this right is not absolute and must be exercised within the limit prescribed by the law. So domestic statutes such as the Societies Act 1966 and the Universities and University College Act 1971 impose significant restriction on the freedom of association, particularly for university students and unregistered groups. So although Cynthia's actions are supported by both constitutional and international human rights, but any perceived threats to the public or morality may justify state intervention. So nevertheless, such restriction must always meet the criteria of legality, necessity, and proportionality. So therefore, while Cynthia has a fundamental right to associate and advocate for social issues, she and her fellow activists must ensure that their activities remain lawful and peaceful to avoid lawful restrictions or regulatory consequences by the government. So that's all from us. Thank you.